Hi, everyone. We're moving on now to Chapter 5. In this recording, we'll focus on the struggle for equal rights. It's an ongoing question to say who is equal in the United States. And I think we can all conclude to some degree that that's not been fully resolved. And there's an ongoing debate on that issue. Who is equal to what, and what level do you determine equality? And that's what we'll cover here today. So again, like the other chapters, then, now, and next on page 160, then we can see that the struggle was to get non-white males to the table, to even be part of participation, political participation, economic participation, academic participation, that just wasn't happening at the beginning of our country. And so that is the beginning point of the struggle. So we now see that states are determining voting rights, and in ways that may limit voting opportunities. And so to say, does everyone have the right to go vote? But you have to go vote in person, and you have to be at a polling station, and there's a limited number of polling stations. Is it accurate to say that everyone has the same right to go vote if one person on average, because of their polling station where they're located, they're able to vote without having more than a 15-minute wait, and another person has to wait somewhere between 4 or 5 hours? Is that still equality? You could come back and say both people did get to vote, but there was an imposition put on one person that the other person did not have to experience. And so that's another way of evaluating equality. And equal opportunities is broadened to consider gender identity and sexual orientation. I think we know that that's where we are today, to look at the issue of equality. And in the future, should protections be extended to non-citizens and people of different body sizes? In what way do we look at the question of equality? And when we say equal opportunities, so these equal opportunities be extended in terms of benefits, such as, or we look at these benefits as being just expected rights, housing and childcare. Do we start to have that type of view to say that we don't have equality unless we have these protections? So a lot to think over there on page 160. This is an interesting question here, brought out on pages 163 and 164. Should discrimination ever be allowed? So we spend most of our time in this chapter considering that there should not be discrimination, but are there times in which, in fact, there should be, or that it's allowable? So in this case, when we can look at some examples today that it's hardly ever allowed, and then some in which there's more of an expectation of a discrimination. So we have strict scrutiny, which certainly suggests by its name that it's hardly ever allowed. And this would be, it must be a compelling national interest to discriminate against a race, ethnicity, or religion. The burden is on the state, and I think we can generally conclude it's hardly ever allowed. Not to say it doesn't happen, but in terms of a policy or a law, it's very rarely happening in our society today. Heightened scrutiny determines the legality of sex-based discrimination. So sex-based discrimination, gender discrimination, probably to be more specific here, we're dealing with sex-based discrimination, does not happen very often, but it is not in the same category as race, ethnicity, or religion. And then you have ordinary scrutiny. State provides discrimination, state proves, discrimination is a rational means to achieve a legitimate public interest. And the general area where we see most ordinary scrutiny allowing discrimination is on age. And so either too young or too old. which then leads us to an interesting discussion. Are there age-based discriminations that are no longer legitimate and should be eliminated? So those of you just taking this online or watching the recording, maybe you can think that one over and say, is there a time that there is an allowable discrimination? We certainly know that there are mandatory retirements. There are ages in which you could buy tobacco or alcohol. Insurance rates are different. So are some of these or something else that you can think of in which it would no longer be legitimate to have age-based discrimination? So let's look over the history here, which your text does a fantastic job of showing the changes that have occurred in this struggle for equality. So perhaps the struggle for civil rights, it started when the Constitution was written. The fact that you had slavery protected by the Constitution and that you had embedded in the Constitution that there are going to be human beings that are just going to be counted less. Having that reality is going to set the pathway towards a civil war, and it's going to set the pathway towards an ongoing struggle on civil rights. Not to say that it would have solved all our problems by ending slavery at 1787 or not allowing the 3/5 compromise, but it did create the situation in which we were going to have this struggle throughout our history, and we certainly are in many ways aware of this. So the Fugitive Slave Act in 1850, you have the courts now deciding that a slave is a slave wherever that slave may be located, and not having the grounds to be able to sue is not ever a citizen, is not ever an equal person. And as a result of that, when you're looking at decisions like that, and we'll see that brought out in 1857 with the Dred Scott case, we can see here then that this is property that needs to be supported even if you're not a slave owner. And so we can look at the Fugitive Slave Act as a way of saying to people in other states that don't have slaves or very few slaves, why should they be required to support the plantationocracy or just the big planters? Everyone has to work for them to some degree, turning in slaves if they are found on your property, all those kinds of issues. And so a lot of that thinking is finally put into kind of a solid interpretation through the Dred Scott case. A slave was a slave regardless of where the slave was located. And so we can see that there in the 1857 decision. So you can see that connection with the Fugitive Slave Act, the idea then that this is property. This is always property. And so that property needs to return back to the property owner. This is very blunt evaluation of human beings. And there were plenty of states, as we can see in the North, that more and more people there were maybe not big fans of African Americans and not big fans of runaway slaves, but they also weren't fans of the plantation owners. And they certainly weren't thinking that they had to do their bidding. And so this started to create the states' rights attitude in the North, that they're not there to support the slave owners. They're not there to help them return runaway slaves to the people in the plantation states. This then led to the motivation of Lincoln being elected in 1860, led to the Emancipation Proclamation 1862 while the war is going on, that slaves in the slave territory where they were part of the rebellion were to be free, lead to more slave rebellions, more resistance in those states, and support then for the Union cause. The war ends in 1865, and you see the 13th Amendment, which abolishes slavery in 1865. The 14th Amendment, key part of that, equal protection under the law. And the 15th Amendment, the right to vote for African-American males, or for all males, really, over the age of 21. So it does suggest that we have a society that is really moving towards equality, at least with Black and white America. And as your text notes, that there starts to be some pushback here. And you start to see this pushback with Jim Crow laws, roughly in the late 1870s for sure. So while there was some movement towards integration in states that had considerable amount of slavery, you start to see this strict separation, which is what Jim Crow refers to, between whites and non-whites. And that becomes, of course, part of the question. Not everybody in America is either part of Black and white America. So the other parts, where exactly do they fit in? How do you come up with these areas of segregation? And there's two main forms of segregation. You have de facto segregation, which sometimes is referred to as unofficial segregation, just maybe by custom, culture, that you would have that. And so if you have neighborhoods that are built up, people of certain backgrounds, races, what happens in the issues of trying to integrate or mix up these neighborhoods. And if it happens in some ways in somewhat of a natural process, then maybe it's not as resisted or protested. Does there need to be times in which there's state involvement to try to ensure that would happen, so you can have some more fairness, especially if we're dealing with different property taxes or other forms of funding that may allow some neighborhoods to be better off than others. So how do you balance that out? And so de facto segregation can be pretty difficult to try to resolve. De jure segregation has its own challenges, but at least there you can look at the law and determine whether or not that law should remain. So de jure segregation is segregation by law. So to eliminate the segregation by law, laws have to be different. And so Plessy v. Ferguson, you're reading your text about this court case that really codified Jim Crow to make the determination that there is separate but equal facilities, and so segregation can occur. It was an 8-1 decision by the courts. Or you could have redlining, where you would have laws written in ways to not have people of particular backgrounds, races, to live in some neighborhoods. It would be redlined out, just written out. If you look at the maps and just say, people of this background can't live here. And so it certainly is a form of segregation. In some ways, you could say it's even a form of slavery, because slaves couldn't leave the plantation unless they had some sort of approval. So in this case, people can't travel in other parts of the city. So ways of looking at de facto and de jure segregation. So in a way, a pushback from that, or a movement forward from that. So in a way, you have the first movement of civil rights, as your text mentions, after the Civil War, and the events of the Civil War. And then you have a pushback from that. And then you have a way, in a way, is this ongoing tension? Are we going back in some ways? Perhaps we don't really like to think about that. But here we're considering the modern civil rights movement from pages 170 to 176. So the whole concept of separate but equal schools, please read about this area here, Brown versus Board of Education. Read about this court case that was inherently unequal, inherently a violation of the 14th Amendment. You can't have separate but equal schools. It does lead to areas of inequality. Then you can look at some of the individuals that were best known to resist the law. So they carried out civil disobedience. I would imagine at least two of these individuals are pretty well known to you. Martin Luther King Jr., I'm assuming everyone's heard of him. Rosa Parks, my guess most people have heard of Rosa Parks. Fannie Lou Hamer, perhaps not quite as well known. She was a civil rights leader in Mississippi and certainly led in the 1960s to try to make changes in the political party process. But in all three cases, you're talking about people who would be willing to break the law. So it's interesting to say, is the law always right? I mean, could the law create an unfairness? Could the law be immoral? And that certainly is the argument that all three of these individuals would make, that it was immoral to have segregation, even though it was the law. And so are there times in which it's the right thing to do to actually break the law? So from their activities and the activities of many other people, and a lot of the political decisions that were being made in this period here, roughly in 1964, you have the Civil Rights Act of 1964, mandate equality on accommodations and employment opportunities in education. So there we can see the importance of making changes in the law. So if you have the law that says that there is segregation in accommodations, where you can be in the library, where you can be, what bathrooms you can use, what drinking fountains you can use, all those things, then now you have laws directly opposed to that, to say that that kind of behavior was wrong, and now we're going to put it in the law that you can't have that. So there you can see the importance of the Civil Rights Act. Along with those same areas is to look at voting. So clearly, if you would look over a state, you'd have a certain amount of African Americans that were living there, and yet the percentage of African Americans registered to vote was very low. It does suggest something's going on. There's some sort of process of preventing a group of people from being able to participate. And so discriminatory voting registration practices were banned from the Voting Rights Act of 1965. Now, as your text will point out, are there still situations in which the federal government needs to interfere with state government in registration practices? And that's not as frequent of an occurrence as it once was because of some Supreme Court rulings. So it is interesting to note the Supreme Court may have concluded that we don't have the discrimination that we had in the past. And maybe on some levels that's true, but is that always true? And is there still a need then to have an aggressive federal government imposing on the practices of states to ensure fair registration practices for voters? There's different points of view on that, and the majority of the Supreme Court has not felt that that's still necessary. But if we start to see gaps in the number of African Americans voting as compared to white America, then maybe it's suggesting that there is some pattern of discrimination that is still occurring. All right, so we can see here then, when we're looking at the issues of, again, primarily Black and white America, we can see that there are still issues that are brought out in your text, looking at where we go from the Civil Rights Act and the Voting Rights Act. And clearly a big issue is the interaction between Black and white America when it comes to law enforcement. This is from Nature magazine just last year. And so I'll just kind of point this out to you. I mean, if you wanted to just maybe Google Nature magazine, you could get this article and certainly information on there. And I'm just kind of throwing this out there for us to say that, you know, there does seem to be some patterns that suggest differences. So Black men are 2.5 times more likely to be killed by police during their lifetimes than white men. Black people who were fatally shot by police seem to be twice as likely as white people to be unarmed. So are there, and this becomes an issue, is there a different attitude and approach from law enforcement dealing with Black America than it is with white America? Why may that be the case if that is the case? And what can be done about it? And that's really where we are with our last issue here, our discussion. We can certainly do this again face-to-face class, but online, you might want to maybe talk this over with some people, or at least consider it in your notes. Is there an answer to different interactions with police in Black and white America? Is there some way to deal with that? Why there are different interactions? How can we deal with that? So that's something to consider, and how can we make a change if necessary to that kind of phenomenon, if in fact that is happening. All right, we'll stop there. Our next recording here on Chapter 5 on civil rights or on equality, we'll look at the gender issue on equality, and also beyond Black and white America and other aspects of this struggle for equality.